Criminal procedure refers to the way the criminal system works. Okay, so you have procedure and you have substance. The penal code, for instance, which deals with burglary, that's substantive law. It will tell you what elements are needed for someone to be accused and convicted of burglary. Criminal procedure, on the other hand, deals with how the system will work. And that's a very important factor for clients to understand. Otherwise, they will be frustrated to the point of not making the right decision. The first step in any criminal prosecution is an investigation by a police department. If the police department determines there is something wrong there, they will either arrest the person or they will send the case to a DA to file charges. Once charges are filed, you go to the arraignment. At the arraignment stage, all you basically do is you declare guilty or not guilty, and that's when the case starts. The district attorney will start handing you discovery, which is police reports and evidence against you. And at that point, your investigator's job is to go out and check all of that investigation and all of those reports to see if they're accurate. You know, I'm proud that we have an in-house investigator who's on call 24/7. He's been very crucial in getting a few cases dismissed. After discovery, if the matter is a felony, you go to what's called a preliminary hearing. There's no jury, it's just a judge. He or she will hear your case and will determine, okay, there's enough evidence to go forward. And then after that, in felonies, you're faced with trial. If you're convicted, then the next step becomes sentencing. And the job of the lawyer at that point becomes one of convincing the judge that rehabilitation can occur without incarceration. Navigating through the criminal justice system is not something you can learn in 1 year or 1 day or in a couple of years. What I've learned through the 18 years that I have practiced law is you can catch a lot more flies with honey, as they say. Some young attorneys have the attitude that the more forceful they are, it's gonna help their client. It won't. An attorney who's done this 18, 20, 30 years has seen so many cases that I can sit in front of my client and honestly, with good conscience, tell him that I think this is a good deal that the DEA is offering. Whereas if you're a young attorney, it will be hard for you to come to that conclusion whether this is a good offer or no. And if a good offer is turned down, it may not come back. And that could be the difference between a client being on probation and doing maybe 20 hours of community service and going to trial, losing, and facing a year in jail. So it's so important that whoever represents you has not only the know-how but the experience as to how the procedure works. And I can confidently tell you that once I have reviewed the discovery, once I've had a time to chat with the district attorneys on the case, I will be able to let my clients know whether the offer made is reasonable or we should fight it more.